Ladies and gentlemen, welcome to the People's Law School. This is an effort by the Alabama Association for Justice, the trial lawyers of Alabama, to present to you the best lawyers in America. And tonight we have Bobby Prince of Tuscaloosa to speak to us. Bobby Prince is a practicing lawyer there. He, at one time, was the president of the Alabama Trial Lawyers, and he has held every office of importance in that organization. Now he's president emeritus, maybe. I don't know what you are when you reach the over-the-hill gang part, but he's a 74 graduate of the University of Alabama Law School, and he's also licensed to practice in Florida. He's got several multi-million-dollar settlements and verdicts in the Tuscaloosa, Alabama, and Birmingham, Alabama area, in fact, all over the state. And he's one of those lawyers that all the defendants like to hate. But Bobby Prince has done his share for standing up for the rights of the little people in our state and protecting all of us. And even though he's still alive, he has a name, he has a wing of the law school named after him. It's the trial wing. The trial advocacy wing now in Tuscaloosa is now called the Prince Trial Advocacy Wing at the University of Alabama Law School. And I think that's quite an honor, as I said, because he's still alive. It is my honor and privilege to present to you my friend Bobby Prince.
Thank you, Alan.
Good to see you, my friend.
Always good to see you. Well, y'all know why they named that wing after me, don't you? Because I've been teaching out there for way too long for no money. So they felt guilty, and they said, well, let's do something in his honor. So they did. No, seriously, I've been trying cases since I started. Tried my first case in federal court, and I was so bad that the judge called me in. This is a true story. Called me in and said, Mr. Prince, I don't want to see you back in my courtroom until you learn how to try a case. It was so bad that the U.S. attorney tried to take up for me and said, oh, Judge, how's he going to learn unless he tries cases? He said he can try them somewhere else. And that's a true story. So I decided that day that I always knew I would like to try cases. So I said, I'm going to learn how. I'm going to learn, and I started reading everything I could get my hands on. I went to seminars where the most famous lawyers in the United States presented, and I started slowly but surely learning how to try a case. But I really started learning when I started teaching. I got a call one day, and this professor at the law school who had a trial advocacy class said, well, how about coming out and helping with the students? Because he knew I was trying cases. Losing them, but I was trying them. And I said I'd be glad to. And ever since then, I've taught trial advocacy at the law school. I coached the Alabama trial team. It's now AAJ, Association for Justice, formerly trial lawyers. In fact, we just returned from New Orleans, where we had already won the region, and we went to compete in the nationals, and we finished third in the nation. Now, to put that in perspective, there were about 175 or so schools that entered teams, and we finished third. So pretty proud of my team this year. They worked hard. They're good lawyers, and they're going to be great lawyers when they get out. Okay, with that background, I didn't tell you all that to be bragging. I told you that because I wanted you to think that maybe I knew something about why lawyers lose cases. Now, you can flip it and say why lawyers win cases. Just do the opposite of what we're going to cover tonight. But it's based on my personal experience. It's based on things I've read. It's based on a survey that I did. And it's based on numerous studies in the United States. So I sent out a survey to roughly 100 lawyers in the state that I knew: Tuscaloosa, Birmingham, Huntsville, Mobile, that tried cases. Not corporate lawyers, not wills and deeds, but people that went in the courtroom. I said, tell me, rank for me the reasons why you think lawyers lose cases. And they gave me that information back in that survey. And it's pretty interesting because, first of all, before I throw up the screen and show you what they said, realize that they weren't talking about themselves. So that when they answered these questions, it was like, well, here's what other lawyers lose cases. Not me, but why other lawyers lose cases. And I know that because I kept looking at the responses from some of them that I knew. I said, he not talking about himself here. He not including himself in this survey, or herself. Okay, here we go. Of those responses, roughly, I think it's 46% said, see down at the bottom in red, 46% of them said, well, look, the reason lawyers lose cases is because of poor presentation. But not me, Mr. Prince, but these other lawyers that lose cases, when they go into court, they're either discourteous to the judge, to other lawyers, to the witnesses, or they lack a good game plan. If they're fortunate enough to have a game plan, they don't exercise it, they deviate from it. They let the case get too complicated. They don't reduce it down, make it simple, and they are very poor in selecting a jury. So I lumped all those into presentation. So they think 46% of their answers, roughly half, was poor presentation. Okay? The next, they said, poor preparation. 27% of the answers, 1 in 4, said poor preparation. And you can see on the screen, it says preparation of the case, in other words, a workup of the case, working with their client, prepping their client for trial, prepping witnesses, not researching the law, and not finding out all the facts. In other words, preparing to go to trial. They said 1 in 4 answers fell in that group. It was not a matter of presenting, it was a matter of preparing, is what they said. Okay, so then the next thing they said, 14% of them, the answers I mean, said, well, it's not the lawyer skills, it's not the preparation, but really it's just things not in your control, like having bad facts. Just your client, the facts are against you in there. Maybe the law's against you. Some of them said, well, you're trying the wrong case at the wrong time in the wrong county. That may be some, let's say there's a big hoopla in a county about maybe some notorious murder where somebody was DUI or a homicide where they were DUI or something, killed. Well, if you go in there in that county trying to defend a DUI death, you're in trouble. That's what they're talking about. Wrong case at the wrong time in the wrong county. And then look at that number D down there, having a bad client. I've got that in quotes, okay? I've got in quotes because I'm not buying that it's a bad client. I think it might be a poor lawyer preparation of the client, but not a bad client. But notice how they were saying, of course, not me, but these other lawyers lose cases 14% of the time because they select the wrong case to go forward. For whatever reason, the wrong case. Okay, then roughly the same amount of people, y'all might recognize Judge Ito there from the famous trial that we watched for months and months with OJ. 14% of them, 13% said, look, it's poor venue. Now, venue is a legal term meaning place, basically. But I included having a bad jury. If you're in a bad place, a lot of times you're going to have a bad jury. Some counties in Alabama, for instance, are very conservative, very conservative. Some are very liberal. Some like plaintiffs. Some don't like plaintiffs at all. And if you get in the wrong county, if you're defending, it can be a big verdict. And if you're prosecuting like Alan and I do, well, you're in an uphill battle. Sometimes we get a bad judge. I've had, all of us, all the lawyers have stories on this where some judge, it maybe is conservative and doesn't believe in a certain kind of case. Well, they'll kick you out of court and make you appeal. They'll rule against you in front of the jury and kind of let the jury know they don't like your case. That happens, not too often, but every now and then. Look at that last one. This may be something y'all don't even know. A poor local counsel. If I try a case in Huntsville, I don't know the jury up here, but Alan does. He lives up here. His children went to school here. He goes to church here. He's socially active here. He knows them. So I call old Alan up and I say, look, I've got a case up there in Huntsville. We're going to be trying it next fall or something. And I'd like to associate you to help me. I'll pay you, X 10% of the fee or whatever. If you will help me strike the jury, keep the judge off of me. And besides that, Alan, you know the courthouse personnel. You know the clerks. You can get things done. They don't know me. If I get the wrong lawyer, one that nobody likes, including the judge, and he or she's bad on jury selection, that's bad. So sometimes local lawyers, the bad local counsel, and that was some of their answers. But I lumped them all together and came up with 13%. Just said, look, you're in a bad place here. You got the wrong county, got the wrong judge. Okay, so there, if you add all that up, it's 100%. All right, now, what do y'all think why lawyers lose cases? Because, see, there have been some studies. I want to see how good y'all do. What do y'all think? What are some reasons why you think a lawyer might lose a case? That's a good one. Sometimes judges are prejudiced. That's exactly right. Yep. A lot of times lawyers are overconfident and they don't prepare the case, they don't prepare the witnesses, they don't prepare their clients, and they don't prepare themselves. They go in there thinking, I'm pretty good, I don't need to do this. Look, that's an important one right there. Any good lawyer knows to not trust everything the client says. Not because they necessarily lie, although some of them do. They could just be wrong about some important fact. So we always go behind the client. The good lawyers do. We don't take them at face value. That's right. We get on social. We get on all the social sites and see what they post, what they're interested in. You'd be surprised at the information, sir.
I think one of the reasons attorneys lose cases is lack of experience.
No doubt. A young lawyer has just got to learn. I always said I want an experienced lawyer and a young doctor. They come out of medical school and they got the most recent research available to them. But lawyers are not that way. Lawyers, you have to go in and do it. You just have to get the experience.
For appeal to the specific judge or the specific jury?
Yep. How you talk to a judge and a jury is very important in selecting them and convincing them. I tell the students at the law school, trying a case is really the art of persuasion. It's the art of persuasion. We're trying to persuade the jury in our favor, legitimately. I don't mean by hook or crook. Well, let me tell you what this survey, they did a survey up in Minnesota, and they studied 109 civil cases and criminal cases. And they asked the jurors after those cases were over. They said that what they were looking for is a correlation between winning and what the jury said made them win. And they also asked them about losing and said, you voted against such and such. Why did you do that? Was the lawyer any good? What happened here? And here's it's all about the lawyers now, not about the facts of the case. In this Minnesota, you can see at the top, I've got what jurors say. Remember now, I asked the local lawyers in the state of Alabama, and you're going to see that most of the things that the jurors say, the lawyers didn't even mention. Like, for instance, let me tell you, lawyers never did mention things like objecting too much. That was never an answer given. There's a couple of others, and when we get to them, I'll point them out, where the lawyers just didn't even talk about it. Let me tell you one right away, because it's one that fascinates me. Any study that you see will tell you that 75, and you see different percentages, but 75% of persuading somebody is not what you say. It is how you say it. It's your what we call nonverbals. Not what comes out of my mouth, but my body language. Is my body language open, like this, see how I'm doing, or is it closed? See, jurors don't like it when the lawyers cross their arms because it's like, you hiding something? What are you doing? So they teach us, you know, open body language, eye contact, eye contact. Don't be looking down at notes, eye contact. See, all these things matter. 75% of persuading you, if you're a juror, is how the lawyer says it. Does he believe in it? Does she or not believe in it? Well, okay. Here's what they said. Now, these were lawyers that had won. The winning lawyers, they asked them, okay, now tell me about your lawyer. You voted on for their side, and here's what they said. Well, that lawyer had good communication skills, exactly what I just said. See, now, the lawyers in Alabama, nobody answered that. Nobody said nonverbals and communication, not one. They said a strong voice, clear and articulate. Nice to listen to. They kept it simple. They didn't make it complex. They did not belabor the point, go over it and over it and over it like some lawyers do. You know why lawyers do that, don't you? They don't trust that you're smart enough to get it the first time. And that's why they go over it 2 or 3 times. And eye contact is so important. Got to make eye contact with the jury. And that's what the jury said. Now, how about the losing lawyers? The ones that lost the case, they said, describe that lawyer for me. Monotone, weak voice, no confidence, dull, talk way too slow, needs to be more concise. He just rambled on and on. He wasn't organized in the presentation of the evidence. These are the losing lawyers. He seemed to belittle the witness, belittling the witness, harsh towards the witness, attack the witness, and split hairs. Of course, y'all know what split hairs, argue over words that don't matter in a sentence or something. Let me digress right here for a second and tell you, when I first started practicing law, it was kind of like the meanest lawyer would win. Every now and then there'd be some lawyer, he or she was just mean to you and run over you kind of in the courtroom, like a fight in a schoolyard. And the lawyers that didn't stand up to that lawyer would lose. Well, over the years, what's happened is these judges no longer permit that. Civility is really big in the courtroom now. Being civil. I mean, you can fight for your client without getting personal. Now, we're seeing some of this personal attack on TV in the race for the president. Personal, not even on the issues, see. Lawyers used to do that. They would belittle the other lawyer. But now judges get on to us immediately when we start doing that. So you see more civility. And you see jurors don't like hostile lawyers arguing all the time. This is an interesting one right here. Well, here's what they did in this survey in Minnesota. They said, if you're through with the survey now, if you've got any comments that you want to write, go ahead and write the comments down. Now, y'all, it takes an effort to, write a comment. Usually when I do a survey, I just take a survey. I'm through with it. I don't want to write. Well, here's what they wrote. They said, why didn't the police get the fingerprints off the defendant's T-shirt, the victim's T-shirt? Now, all y'all have seen CSI. I mean, you can't turn on the TV without seeing CSI Los Angeles, CSI New York, CSI Nevada, wherever. Yeah, CSI. People are watching crime shows, then going into court and being jurors and using what they learn on TV to compare to what the lawyers are doing in the court in Alabama. Asking them things like, why didn't you do such and such test? Why wasn't the powder burn test done on that, on his hands? See, that's what we call the CSI effect. Lawyers know about that now, so we try to guard against it. We tell jurors in the opening statement and in closing argument, and we get our experts to say, it's not like CSI on TV. If we don't do that, jurors get back there and say, well, they didn't prove their case. They didn't even do the blood analysis on him. 25% of them said, I want more evidence. But what they ended up saying on that more evidence was the things I'm telling you right now, additional tests that they'd seen on TV. Okay, did a Florida survey. We were in Minnesota. Now we're going to Florida. And in Florida, what they did is they went to 9 different counties, and they asked them, I think there was 1,000 jurors were questioned, and they said, we're trying to correlate between the ability of the lawyer and whether that lawyer wins or loses. And here's what the Florida survey said. And they did criminal and civil cases. The years was 03, 04. Here's what they said. Lawyers who come across as believing in their case. Now notice this has nothing to do with facts. Who ran the red light? It has to do with the lawyer's attitude, the nonverbals that the lawyer is emitting. Does he or she believe in her case? Because if they do, they equated that with better ability. Ability, which y'all know it has nothing to do with ability. You could have no ability and believe in your case and be dead wrong. But the juror said, no, it does. And, you know, the way they did this polling or sample, they didn't just say fill in the blank. They would have, you know, like 5 things, just rank these 1 through 5 on your lawyer. And then they would correlate all of it, and they came out with believes in the case is a better lawyer. Lawyers who get to the point and don't ramble and ask important questions, they are better lawyers in ability. And we like that lawyer more that doesn't ramble and keep repeating himself or herself. Now, this is a very interesting survey of why a lawyer loses a case. Look at that top one. Lawyers who object too much don't have as much ability as the other one. Now remember, objections was not to be found in the Alabama survey. When I sent it out 100 to the 100 lawyers, not one said, well, you lose the case if you object too much. Well, y'all know that you do. You know what studies show from jurors? See, the organizations like Alan is in, and that I'm in, the Association for Justice, we've spent a lot of money going and asking jurors. We have mock trials and focus groups where we bring you in. We show you something and we say, what do you think about that? We're trying to get to the issues of what wins and loses a case. So there are a lot of things that we know already about this because we've studied it. And one of the things that, you know, we know is that a lawyer that's too aggressive, people don't like that. If you're too aggressive, back to that harsh stuff I was telling you about. If you're too harsh with a witness, jumping on a witness, the jurors end up saying, well, I don't really like that lawyer, and they vote against him or her. So it matters. What you do in the courtroom has nothing to do with the facts of the case. Not one thing. It has to do with the lawyer performance. Look at this last one. I told you about how lawyers used to be mean to each other. Lawyers who are honorable in presenting their case came out to have increased ability. If they were honorable, if they were fair, respectful to the judge, didn't try to twist the facts, they said that lawyer is better than that lawyer. Now remember, it's not a one-on-one thing. It's not he was honorable so therefore he's better. It was, here are all these different answers, and they had to correlate them to come out with this. It wasn't one-to-one, you know. In other words, they didn't ask him just like, okay, was he honorable? If so, you know, was he better, have more ability or not? They didn't do it that way. They kind of had all this information that they combined to come out with these conclusions. Okay, they did another study. This one was for criminal defense lawyers across the nation. Look at that, where it went. New York, Arizona, California, and back to Washington, D.C. So this from East Coast to West Coast. Interviewed jurors, and this one was another, you know, big study from cases over a long period of time from all those 4 states. And they said, may I ask you a question, juror? So you've been sitting on criminal cases, I mean. Some you voted for defense, some prosecution. How much do y'all think that a lawyer's ability entered into it? And now they ask them just sort of a broad question, not in their trial, just in general. Do you think a lawyer's ability should affect the outcome of the case, or should the facts control it? In this survey, 56, over half of them, almost 60% said, no. If one lawyer is better than the other, it does affect the outcome, in my opinion. Okay? But then when they ask them, well, what about cases that you sat on? The ones that you rendered a verdict on, did skill of the lawyer enter into it? And the juror said, oh, no. No, it didn't enter into me. In other words, how can you say 56% of the time the skillfulness of the lawyer matters, but in a case where I'm a juror, it's only 35? You know what they're saying, don't you? But I'm objective. I can look past that. Now, these other jurors, they can't do that, but I can. So I thought that was pretty interesting. Okay. Well, now you have it. You got what Alabama lawyers said. You have what jurors say, and they're not necessarily the same thing. I hope y'all picked up on that. Here's my list of the top 10 reasons, not necessarily in order, because it would be impossible to rank these in order. But kind of the ones closest to the top seem to be more important to me anyway than the ones at the bottom. I learned a long time ago, like when you're a teenager or something and you're picking, the guys would pick a baseball team and they got a bunch of people standing around like this and say, okay, Prince, you pick first. So yeah, I'm going to pick the one I think is the best player, okay, for my first pick. I got 8 more picks, but the first one, I'm going to make sure I get the one that can hit and field and, the best player. Well, this would be my first pick. If I was going to trial and somebody said, you can have whatever you want. You can have a good judge, you can have a good venue, you can have whatever you want. Good facts. I'm going to say, no. I think the lineup of the parties is the most important thing. If you give me somebody that's likable, somebody that's honest, somebody that doesn't stretch the truth, I will take that any day of the week over against a corporation or somebody that makes a bad impression. I think the lineup of the parties is so important because when we ask those jurors to judge, if they really like somebody, they'll find a way to root for them if they can, without just violating the oath. If it's close to a tie, they'll root for the one they like. I've seen that. One of the earliest cases I ever had. I now know people don't like motorcycle cases. Didn't know it then. I was a young lawyer trying cases. I was back when the judge said, don't come in here unless you know how to try a case. I had this case where this young teenage boy was on a motorcycle. And he was in a curve, and this elderly lady crossed the line into his lane and hit his motorcycle. Now, let's just stop right there. How did you lose this case? I mean, it's her fault. There is no doubt about it. She crossed over the line, okay? So I noticed that the insurance adjuster didn't offer me much money. So I sued. And I noticed the defense lawyer didn't offer me much money. I thought, what's going on? Because my guy had a broken leg. He was injured pretty good. So I tried the case to a jury. 0. This little old lady was so nice and likable. And I had a teenager, he was scruffy looking. He was on a motorcycle, that's strike 1. He was young, strike 2. They loved her, strike 3. And if there is a strike 4, this is it. You know what she was doing? It happened on a Saturday afternoon about 2 o'clock in broad daylight. She was taking flowers to the church. They rolled that verdict to me. 0, egg, nada. And I learned something. I said, how'd I lose that case? And I went back home and I kept thinking about it. I thought, I lost it because they liked her and they didn't like my client. And that's proven true.
Wouldn't you want to just change that venue and just have a judge trial?
Exactly, if you can. But see, these defense lawyers are smart too. See, they don't if I don't ask for a jury, they will. And you see, and I can't just move it to another county. the law is pretty rigid on where I can have that trial. So yeah, it'd be nice if I could do that, but a lot of times you can't do it. Of course, having liability against you. You know, it wouldn't do you any good to represent somebody injured in a car wreck case where your client ran a red light. Let me tell you when this comes into play. Sometimes Al and I start feeling sorry for people. You know, we're human, and we like to help people. And every now and then, even though the facts are against us, we take a case we probably shouldn't take, trying to help. When there's liabilities against you, 9 times out of 10, you're going to lose it. There's that unappealing party that I was telling you about. How'd you like to take that guy into court? Nobody would vote for him. I don't care what the facts are. Look at number 3 down there, a bad venue. I think that's critically important. I could have a good client. I could have the law on my side and the facts. But if I'm in a county that's ultra-conservative, and we've got 2 or 3 of those, they come into court, jurors do, thinking, Prince is trying to stretch his case here. He's trying to, they used to say, roll the dice. Y'all have heard some of these, jackpot justice, some of these terms. And the jurors would come in looking at the case through a lens of bad for the plaintiff. And another big one was the businesses got the word out that everybody needs to take responsibility for their own actions. I bet if y'all know, y'all have heard that. Defense lawyers use it all the time, and jurors were starting to rule against people who get hit in the back at a red light, okay? Clear liability, and they have a soft tissue injury, juries are giving them nothing. I'm not kidding, because the big insurance companies have influenced jurors to the point now where they say, well, the plaintiff's just stretching that, you know, probably. There's some cases in California where they do it on purpose. I've even had jurors tell me that. You know, in California, I've read where they stop in front of somebody just so they can go, you know, make a claim. I said, well, we didn't do that. They go, well, I don't know. So having a bad venue, now it's more than just the bad jury. You can have a bad jury, but in that, see, I'm lumping it in. You get a bad judge, I don't care where you are, he'd kick you out of court. See, that judge, he's studying on it right there. He's already made up his mind. He's going to kick me out of court. See, he's up there right now, contemplating. Now, I told you about the bad local counsel. See, all that, to me, falls under bad venue. Bad, you know, it's a bad place because the judge is bad, jury's bad, bad local counsel. Here's one that's really coming of age, this one right here. And I do believe that this one is probably the most important thing a lawyer can do. Now, I'm giving y'all some insights here. We never used to do this. Used to when we had a case. We might walk in there to our secretary and say, what do you think about this case? Is it any good? And maybe we'd ask another lawyer. That's as far as we'd go, because most lawyers think they know everything anyway. You know, they say, well, a jury going to give me a lot of money. Well, no, they don't. They're not going to. So what we do now is, if I've got a big case, I wouldn't think of trying a big case, one that's where somebody's really been hurt, without bringing folks like you in. It's called a focus group. And we say, let me tell you about the facts of this case. And then I'd get your impressions. How would you rule on that? And I give it to you from the defense side. I don't give it to you from the facts favorable to me. I give it to you from the worst facts for me. Worst case. Then that way I know if you like my case with me giving you the worst facts, then I'm in pretty good shape. I'm amazed at how many times jurors see issues that we don't see, lawyers don't see. I can give you some examples. There was I'll give you a quick one. I think we got time. There was this young lady, I think she was, when I say young, I think she was in her 30s, in a hotel out in, I believe it was Texas, somewhere out there, Louisiana, Texas, Oklahoma. She was in a workout room, you know, one of those rooms where you go in there and get on the treadmill and watch the news on TV. She got up early, nobody else was in there, and she was on the treadmill, and she had a heart attack and fell off the treadmill, and before anybody could find her, she died. So they sued. And before they sued, though, they had a little, what we call a mock jury. They brought in people like you and said, here's the evidence. You can call them focus groups, or you can call them mock jury, whatever. And all the lawyers thought it's a great case. And they said, well, you know, the hotel didn't have security films. If they'd had a video, they could have seen she was down and gone in there and helped her. The hotel didn't have somebody in there. If they just had somebody in there, you know, this is what the lawyers were thinking. They focus grouped that case 3 times. 3 times in a row, the jury, y'all, said no, no, no. So finally, the lawyers wised up and said, okay, we're not going to present any evidence. Let's just talk about it. And they just said, look, girl goes in there on a treadmill, has a heart attack, and they start describing everything. And one juror says, did they have anything like to resuscitate her? And they go, oh yeah, they had one of those, you know, defibrillators over on the wall. And but nobody was in there to run it. And they said, well, if that defibrillator was in there, see, the lawyers hadn't even mentioned that. And from that, the lawyers said, aha, and now we got it. And so then they went in and got a multi-million-dollar verdict because they proved that it would have mattered. See, the jury, without the defibrillator, the jury's just thinking, well, what could they have done? If they were in there, nothing, right, nothing. See? So that's a good example of how a focus group turned a case from, if they'd have gone in and tried it the first time, with the way the lawyers were thinking, 0. So mock trials, this is something that's really come of age. You see mock trials and focus juries a lot. A lot of the firms are doing them, and as I said, we do them routinely. I wouldn't think about going into court. Because I finally figured out, lawyers don't think like like regular people. I mean, we're in our own little world about, you know, legal terms this, judges that, lawyers, we're trading information. I mean, even though we go home at night, we don't think like y'all think about issues. It's just a fact. Nobody's right or wrong. It's just different. We think differently. And until we start figuring out what y'all think is important, we're wasting our time. Okay, I think a poor voir dire. Now, voir dire is when the lawyers ask questions. In the beginning of the trial, when they bring all the jurors in, lawyers get to ask questions, and then from those questions, they take that information down and we pick a jury. Well, actually, we don't pick a jury. We mark off who we don't want until the 12 least egregious people, the 12 that are left, is our jury. Lawyers used to go in and try to argue their case during a voir dire. They would say, now this case is a, you know, a wreck case and blah, blah, blah. And how many of y'all think that, you know, should get money if somebody's injured? You know, in other words, they would argue their side, but we don't do that anymore. Not good lawyers. Good lawyers go in and we want to try to ferret out who's going to be ruling against us, who doesn't want to talk about it in open like this. You know, who has got a prejudice against people that are claiming injuries? Because if I ask the jury, if I say, hey, well, everybody, can you be fair? Well, they all going to hold their hand up, oh, I can be fair. See? But if I start asking open-ended questions and I get you talking, you know, and I say, like, who thinks there's too many lawsuits? And the hand goes up here. And I go, tell me about that. In other words, I don't run from it. I bring it out. And you say, well, I've heard this. And I go, does anybody feel any differently? And somebody over here goes, well, I feel differently about it. And so I get them talking. You see what I mean? Well, I know now. I don't want you. I want you. I saw this guy back here nodding when you were talking. I want him. See? I'm not going to strike him off. So we've changed how we voir dire the jury now. We no longer try to go in there and convince you at the beginning. That used to be the prevailing thought about how to do it, but that's the wrong way. And we finally figured it out why. We asked the jurors, and they said, well, lawyers, I mean, first of all, we know you're in there arguing for your client. You know, I mean, that's Arabic for we don't really believe you, okay? And here you are, somebody we don't really trust and believe, and you're trying to argue your case, and it hadn't even started. And that's what the jurors said. So I no longer argue my case in the voir dire. I try to find out. Poor preparation. You know, a lot of lawyers lose their cases because of this. They don't get all the important facts. They don't prep the client properly, and they don't prep the witnesses. Let me just tell you a little bit about what I'm talking about. I'm of the opinion you win or lose your case before you ever file it. Before you ever file it. You win it in the office. What am I talking about? I'm talking about finding out every fact witness there is. Talking to that witness. Finding out what their story is. Getting a statement from that witness so they can't flip on me later after the insurance adjuster goes and talks to them, or the defendant's investigator. Sometimes we record them. And then, of course, if it's a lawsuit's filed, we take their deposition. We ask them to come in, put them under oath, ask them questions. All right, so you got to find out the facts. I like to say the good, the bad, and the ugly. I don't care what it is. I just want to know. I don't want to find out in the middle of a trial some fact that, you know, that I'm not prepared for. So, all right, client. I think you got to get the client's expectations down. Now, some lawyers get them sky high expectations to get the case. They'll tell you anything to get the case. I know this from experience where lawyers have sent letters. Some famous lawyers here in Alabama have sent letters saying, I am an expert in train wreck cases, like send it to the widow. I can get you $1 million. The widow comes to this lawyer, because he's got a big name, signs up on the contract. The lawyer ends up settling the case for $100,000. Her husband got killed, didn't get $1 million, got $100,000. And so that's all the insurance they had. But he just wanted to get the case in. Well, you know, I'm just saying, you got to get the client's expectations down, not too high, more realistic. And I go over it with them. Good lawyers, actually, I've taken them to the courthouse before. Here's where we're going to be. Here's a witness stand. I've videotaped them before. Here's the questions we're going to ask you. Now look right here. You see how you folded your arms and blinked your eyes and looked down? I know you're not telling a story, but unless you keep looking straight ahead at that jury making eye contact, they might think you're not telling the truth. You got to prep the client, inform the client about how to best present themselves. It's not illegal or dishonest, it's taking full advantage of the rules. Lawyers who don't do this oftentimes lose. Do the same thing with a witness. Don't have as much control over a witness, obviously, but we do say, look, if you take notes up there, they get a chance to see them. If you don't look, and we even tell them, you know, witnesses, the studies have shown, if a witness kind of leans forward in the witness box, that jurors think they're more believable than if they lean back and slouch. So all that matters. So we tell them that. See, now some people you just can't prep. Some people are going to say what's on their mind regardless of what the lawyer says. And that's when I was telling you about, we don't stigmatize them. You know, we try to record them. You know, in Alabama, you can record without telling somebody as long as one person to the conversation agrees to it. It's legal. I could record a phone call with every one of y'all. We could have a conference call, and I don't have to tell anybody I'm recording because I got my own permission. So I'm one of the ones. Just remember that when the insurance adjuster calls you up from the other side, they can record it. They don't have to tell you about it. I told you about not reviewing them and not recording them, not getting a statement, not taking the deposition. That's the poor presentation of facts. But sometimes lawyers lose cases because they don't adequately research the law and jury instructions. See, here's what people don't realize. I'm amused on TV when they start saying, well, now, a judge should not make law. I hear this from the conservative groups, from the Republicans. I mean, that's the battle cry. These liberal, democratic judges are making the law, and they shouldn't do it. Well, I have a news flash for y'all. Alabama, we've got an all-Republican Supreme Court. Some of them are my good friends. Some of them are going to see this show, so I quickly will say they are my close friends. But every Friday afternoon, when they rule, that's when the cases come out. They change the law. They're not the legislature, but there's a change. And if I don't keep up with it, those jury instructions are based on the current law. So I can't, you know, like let's say you come to me for a product liability case or whatever. I can't use my memory of a case I had 3 years ago to say I know what the law is and start preparing my case. I've got to go look at those new jury instructions, because some Friday afternoon, the Supreme Court changes one little word or two in an opinion, and it can matter on a jury instruction. So believe it or not, lawyers actually don't keep up as well as they should, in my opinion, in the preparation. I told you about nonverbals. I'm big on these nonverbals. Look at how he's dressed. I mean, all the studies have even down to what color to wear. You know, jurors think dark navy, dark grays are a lot more trustworthy than some kind of light suit. And so it goes clothes, posture, the actual how somebody sits at the counsel table. If they're sitting there like this, you know, leaned over or reared back, the jurors subliminally say, that lawyer's not prepared, not organized, don't like him. Posture, believe it or not. Hands. All right, I crossed my arms for you a while ago, but the studies show even templing like this. That's, the jurors say, well, I didn't like, there was something about him I just didn't like. And we break it down and we figured it out. And this, well, there's just something about that lawyer. He just wasn't trustworthy. See, I'm hiding my hands. That's why they teach us. You keep them out here. Keep them palms up, open. I'm not hiding anything, see? So hands, positioning in the trial. Believe it or not, do you know where the best, if y'all are the front row of the jury, studies show 6 to 8 feet is the optimum. If closer, and I'm getting in your space. Further back, I'm too distant. You don't feel bonding with me. 6 to 8 feet, I'm on to something. How about movement? When somebody, watch the next lawyer do an opening statement or a closing argument. If they stand there like a statue in one place, the people, it's not as interesting. It's not as interesting. You have to have some movement. Now, we don't want to be a lion in a cage either. So if you watch them, the ones that know what they're doing, they'll take a couple of steps like this. Maintaining eye contact, talking to you, but not forgetting these jurors over there or in the back. Then they'll step or two after a minute or two and they talk here. They move, but it's so subtle, it's almost like you don't realize they're doing it. But if they don't move, you definitely will notice it. So all that matters. All right, this is what I teach. So I could spend a week on this stuff, but I know time won't let me, so I'm just going to tell you that in a good opening statement, so y'all can watch for this, is a story. It's a story. If the lawyer tells a story in the opening statement, they know what they're doing. They don't tell you a story, they don't know what they're doing. Why? That's not what I think. The jurors. Again, now we have interviewed thousands, and they come back and say, well, that lawyer had they convinced me in the opening statement, and we broke it down, and it's common sense if you think about it. How do you learn? How do we learn when we're young? Stories. Your mother, father, grandmother tells you a story. Hey, the greatest teacher of all time, I told you I was going to talk about Jesus. The greatest teacher of all times taught in stories. Now, whether you think he's the Son of God or not has nothing to do with it. He was brilliant, and he taught in stories. Well, that should tell us something. If he's going to do it, then I'm going to do it. My opening statement, I'm not going to stand there and tell you things like, and the evidence is going to be, and you're going to hear. No. You tell a story. On August the 8th, a young man, 25 years old, walked into the bar. He was celebrating his birthday, and during the next 8 hours, he was served 21 drinks. Oh, they said it was watered down, but he got 21. He got in his car, pulled out on the highway, and smashed into my client. That's what this case is about. Did you see, you get the story there? You now know everything that happened in that case. I'll fill you in on the details during the trial. Story, opening statement, direct examination. You know what the jurors say? The lawyers just lead all the time. They just lead the witness, and we don't want to hear from the lawyer. If the lawyer is asking questions on direct, the next trial you see, and the witness is only saying yes or no, that's the poorest way, because then the jury, y'all have to believe the lawyer And you don't want to know what the lawyer says. You want to know what the witness says. How do we do that? Open-ended questions. Why did you do that? How did you do that? What did you do? See, make that witness talk. That's what the jury likes. Cross-examination. Does the lawyer ask leading questions, or does the lawyer ask open-ended questions? We don't want to ask an open-ended question. On cross-examination, that witness is liable to say anything. So when Alan, when he's cross-examined a witness, he testifies. He'll say, now you were in your car about 8 o'clock, weren't you? Yes. And you went down Highway 60, didn't you? Yes, I did. And before you got in your car, you had already had 3 beers, hadn't you? See, he's testifying. You see the difference? He's controlling the flow of information. Good lawyers, that's how they do it. Closing argument. This is one of my favorites. I still see this today. Well, let me back up. When I was a young lawyer trying it with an older lawyer, I remember, plaintiff goes first and last on closing argument. First, because we got the burden of proof. First, then the defense lawyer, and then we get to rebut it. So he said, you go first. And I said, what do you want me to say? He said, just go over what the witness's main testimony. And that was for years how people did it. That's so boring. We would say, you know what I liken it to? It's like me telling you about a movie that you just saw. Now, how smart is that? Instead of doing that, and that's what we'd say. Now, we call Officer Smith. You remember Officer Smith? And he said, well, he did. I did call him. You heard it. Why am I telling you what you heard? George said, give us something new. Give us something we can use back there to decide the case. Don't just go back over the testimony. Tell us why you should win and why the other one should lose. Don't just go back over the testimony. But lawyers, a lot of times, will just go back over the testimony. Objections, like I told you, I think it's real important. Lawyers mishandle things. And this is the last one. This is one you can watch for, and I think it's real important. Lawyers who stretch their cases, okay? Let me give you an example. If I've got a case where a car wreck, where somebody runs a red light at an intersection, plows into my client's car, my client goes to the hospital that night by ambulance, and they take x-rays, they got a cracked rib, they got a broken arm, and they got a strained neck. 3 injuries. Okay? I'm interviewing my client, and I say, have you ever hurt your arm before? No, sir. How about, have you ever had a broken rib? No. How about your neck? Well, yeah, 2 years ago, I did go to the chiropractor, but I'm good now. I wasn't hurting before the wreck. Okay? The defense lawyer is going to get all the medical records, and he's going to ask my client, have you ever hurt your neck before? Then they're going to get the chiropractor's records. We're going to go into court. The defense lawyer is going to say, we don't mind paying for what we caused, but we don't want to pay for some prior injury that this woman had. Okay? So here's what I do. Now, lawyers who are not that experienced, they claim all 3 injuries. But I'm not claiming your neck injury. I'm sorry, I'm not going to do it. Because I know I'm going to get you more money for a clean break on your arm and a broken rib, just the 2 of those, than if I dilute it and go after your neck, because I'll be stretching my damages too far and the jury doesn't like it. That's one way to overtry the case. The other way is, if you prove something, if a lawyer calls 2 witnesses to prove the same thing, you just need to say, I remember Mr. Prince talking about that. And you cannot do that, because if I prove it the first time with your testimony that the light was red, a lawyer who doesn't know what they're doing calls a next witness to prove that light was red, thinking, well, if I have 2 witnesses, the jury's really going to believe me. Well, here's the problem. If you do a good job, I can only go down or tie with him. He can't improve it. And 9 times out of 10, the defense lawyers figured out some question to ask that second witness. So lawyers who overtry their cases, get ready. They're probably going to lose or get a less verdict.
Thank you so much.